On Christmas Eve 1974, plaintiff Alice Fledging was born. Tragically, she entered this world with congenital limb deformities, that is, without limbs below her elbows and knees. Years later, believing that her birth defects were caused by his exposure to the chemicals used at his place of work, her father, the plaintiff William Fledging, and she joined with other current and former employees of defendant International Business Machines Corporation and their children in commencing litigation against IBM and numerous chemical manufacturers and distributors, the supplier defendants, which sold IBM chemicals used as the manufacture of computer microchips. Because their claims have been determined to be time-barred by the governing New York State statute of limitations, Ms. Fledging and her father, together hereinafter plaintiffs, move this court for leave to amend the complaints filed by them in the semiconductor litigation pending before this court, involving approximately 190 other plaintiffs, so as to obtain the benefit of the Comprehensive Environmental Response, Compensation and Liability Act of 1980, 42 U.S.C. Section 9601 et sec, hereinafter CERCLA, as amended by the Superfund Amendments and Reauthorization Act of 1986, 100 Statutes 1613, hereinafter SARA, and specifically 42 U.S.C. Section 9658, which preempts the accrual date for state law toxic tort actions based on exposure to hazardous substances released into the environment by facilities as defined by CERCLA, and permits such claim to accrue upon the discovery of the cause of the injury. In re. Fowle Brothers Landfill Litigation, 26 F. 2nd, 512, 517, Western District of New York, 1998. In this case, presenting an issue of first impression for this state's courts, notwithstanding this court's sympathy for plaintiffs' plight, because their claims do not come within the scope of the relevant CERCLA provisions, their motion for leave to amend is denied. Mr. Fledging was employed by IBM at its East Fishkill, New York facility, the New York plant, from July 1973 until 1976. During this period, he worked in various capacities, some of which related to IBM's manufacturing of semiconductor chips. The process of manufacturing those chips, which was and continues to be done in certain areas known as clean rooms, exposed Mr. Fledging to a variety of chemicals manufactured and sold to IBM by certain supplier defendants. Mr. Fledging and Ms. Fledging have inserted or asserted claims in 2 of the currently pending 22 complaints, theirs being included in the actions filed under the captions Zachary David Ruffing et al. Versus Union Carbide Corporation et al., Ruffing the First, and Zachary David Ruffing et al. Versus Hoxt Celanese, aka American Hoxt et al., Ruffing number 2, which were commenced on August 13, 1996 and October 2, 1997, respectively. These cases and related ones were the subject of certain preliminary motion practice before other Supreme Court justices, resulting in rulings which included one designating the case of Zachary Ruffing, the Ruffing case, as the first to go through full pretrial discovery and trial. Sometime thereafter, all of these actions were assigned to this court. Ultimately, the Ruffing case was resolved, and this court designated the next 8 cases which would be tried the fast-track cases. As the fast-track cases have progressed through the discovery stage, both sides of the litigation have moved for various forms of relief. Among the motions made by IBM and the supplier defendants, together hereinafter defendants, was one seeking summary judgment dismissing plaintiffs' claims filed in Roughing 1 and Roughing 2 on the ground that they were untimely asserted. In opposition to that motion, plaintiffs argued that they had set forth claims under CERCLA, thereby enabling them to the benefit of the more favorable accrual date, which would render their claims timely. Then, in response to defendants' reply papers in which they argued that workplace exposures are not covered by CERCLA, plaintiffs submitted a letter in which they contended that if their specific factual claims did not bring them within the scope of CERCLA, they were nevertheless entitled to rely upon the statute because of their use of general language to the effect that Mr. Fledging was exposed to chemicals in the clean rooms and elsewhere. I remember that CERCLA, we had that a lot in the federal court.